Okay, guys, listen. I am Udayasri, your lecturer. Today we are going to discuss regarding the law of contract. Fine. Do you guys have any idea regarding contract and the law? If you guys will start talking to me, the subject will be very interesting. Usually, I prefer physical classes, but this is the first time that you are going to learn law. Unfortunately, this is unfortunate for me to conduct a lecture on online, but fortunate maybe for you because you guys may comfortable in this. Anybody tell me, do you guys at least drop a message? Do you guys have what is your idea about law and contract? And you guys are management students. Why there is a subject called law or contract law to you? What do you guys think? People can Piumika, tell me, Pasindu, anybody? At least drop me a message. Chat in chat box. I'm audible, right? Okay, fine. Yeah, thank you. Who is that? Malshi, thank you. Thank you. No response. What shall we do right now? So you guys are going to listen whatever I'm telling. Is that so? To control people. Wow. Madhushani. That's fine. Great. To control people. So do you, who Madhushani? Okay. Madhushani, do you think that you are going to control people? Think, my dear students, you guys are management students, going to interact with people, how to speak. Who is that? Don't cry. No, just subject, man. Don't think that you have no idea because law is nothing but it's all about us and our behavior. For an example, take your home, your father, your mother, there are your siblings, and you're interacting with teachers, other friends. Also, you are traveling. They are unknown people. We are interacting with unknown people. Everywhere, low controls. So, people, you have to understand there is set of rules which will regulate your behavior. That is called law. Okay. At least react something. If you guys are not happy with the subject, is it so? I will make this interesting. Don't worry. See, first of all, we'll take 5 minutes to think what is flow. No need to think because I don't know whether you guys are thinking or sleeping. We'll talk. Still, people are coming. No punctual. It's okay. I'm recording. They can listen to the recording, the latecomers, but don't worry. Not much discussed. Now only we are going to enter into the subject called law. Okay. First of all, we have to understand. See the word we. I'm not telling you, we. Because we all are Sri Lankans living in this land and the sovereign body called state and the law. governing us. If there is no any control, we will become as a barbarian like. If nobody is there to control us or our behavior, or if we will not fear to anything, if we are free to do something, we will violate each other. And what will happen in the last? We will destroy everything, including life, nature, resources, everything. There is a saying called after death, there is hell or heaven. But if there is no law, we will create hell in this world. Because of that only there is law. According to my experience, what I understood to you guys, to management students, giving idea regarding law, contract, and certain related other matters will be effective rather than elaborating much more things. Okay, so now you have, all of you have to drop me a message. Should I elaborate a lot thing, or if I will give you certain ideas regarding law and other related matters, will be fine. Because you guys are going to write the exam. Definitely, I know that you will refer to the notes just day before the exams. Because earlier students also did the same, but don't do so. Study from the beginning. Otherwise, you will find difficulty in the exam. Just tell me the way right now I'm doing is fine. So do you guys want much more explanation? Do you guys preferring any notes to be shown? What do you guys think? Will you be sharing slides? Yeah, sure, I will. That's a slide. I will. Before that, just I wanted to make sure that you guys are comfortable with this lecture and you guys have any idea regarding this subject, like, but you guys are not open up. Give me a second, I will share. Okay, can you see my slides? It starts with Unit 9, termination of an offer like. Okay. So please guide us how to write exam answers. Yeah, sure. The important areas that we have to pay attention in syllabuses. Yes, yes, Marsha, yeah. Make me sure that the slide is sharing.
Yes, I can see the slide.
Okay. Now it's changing, right? The slides. Okay. So some of you gave me some ideas to do the lectures. Now I will start. Later we will decide what we have to do. Like, okay, we'll start with Unit 9. Do you guys have your course materials? Number 2, block number 2. They are Unit 9 and 10. We are mainly today we are going to discuss. Now Unit 9. Basically, the Unit 9 is about termination of a contract and the performance breach of contract. It's not frustration, it is frustration. It is frustration and the agreement. Before entering into the lecture, still people are joining. No punctual. It's distracting me. I don't know what you guys are looking at. Okay. People understand that there is a contract. Since you guys are management students, in the future, definitely you will enter into a company or will start your own business. Whatever you will do in the future, you guys have to follow certain rules. That is law. Okay. For an example, we'll say you are a boss. I am the employee. I am trying to reach you, contacting you, and willing to enter belongs to you. Whether you will allow me or you will disallow to be an employee. If you will allow me to be an employee in your firm, if that firm is an organized one, registered one, and if you are following certain rules and if you have some discipline in business, definitely you will enter into a contract with that employee. Okay. In a contract, first of all, as an employee, the boss, you will offer a job to me. I will accept that. Be mindful with the terms that I'm using, okay? Because that will be very useful to understand the subject. Okay, guys. Many joined. Okay, that's fine. As a boss, you are offering me a job. As an employee, I am accepting that job. So you gave, I accepted. This is basic contract. We'll say we entered into a contract, but actually we want to terminate or end up with that relationship. May I give you simple explanation or example? See, I am man willing to marry a girl. I am married. What is this? Contract of marriage. Marriage is a contract. Okay. So in every aspect, we are governing by set of rules and regulations, and we are entering into contract. For an example, for instance, another instance, all of us are going to a shop, giving money in order to purchase anything. The shop owner or the person who is working there will provide that goods to us. There we are entering into a contract. Okay. We say we are going to buy a computer, mobile phone, wristwatch, a shoe, a shirt, whatever, anything. if we are paying money and if we are collecting that, it's called law and contract. Okay. When we are regulating under this kind of rules and regulations, we have to have an idea when it starts and when it ends. Can you understand what I'm trying to say? People, just tell me whether you guys are clear whatever that we discussed up to now, because we didn't start the lecture actually. I'm giving you overall idea, otherwise you can't understand. If the basic is not uh, clear, find difficult. Okay. Exactly, I want to share. Fine. Okay. Now I changed the sharing slide. Now I'm showing you the termination of contract. Just a PDF file. Can you guys see that? Make sure me. Dear students, make sure me. Drop a message.
Visible.
Yeah, thank you. Thank you. Visible. That is fine. But my first question was whether you guys got an idea regarding law of contract. What is contract? Did you get an idea? What is contract? And wherever we are engaging into a contract. Tell me, did you guys get the point? Otherwise, you will find difficult. Trust me. If you didn't get this, you will find difficult. Yeah, we can see, got it. Malshi. Yeah, thank you, Malshi. So hope that other students also got the point. Now I'm going to discuss regarding termination. Now we started uh, functioning under a contract. There are some obligations we have to fulfill. We'll say, I'm going to a car company and I want to buy a car, uh, customs one, customizing. I'm telling that guy that car must appear like this, the tires must be like this, and the engine must be this kind of horsepower. Like I'm giving some descriptions. And that car company also manufacturing according to my will. Now I entered into a contract. Okay. Okay, fine. After manufacturing, I'm paying and collecting the car from the company. At the moment, the contract is finished there. Because just I wanted a car from them, they manufactured, they delivered. That's all. But we'll say there is a contract of employment. So there will be a boss, there will be an employee. The contract will exist until the offer validates. That means until fire the employee or the employee will resign the job. First of all, you have to understand when a contract starts. Then you have to have an idea when a contract stops or ends. See here, these are some examples. These all are some examples. These all are some examples where a contract terminates. See, termination of an offer. You guys go and read the block 2. I'm not going to dictate each and every words here. I'm going to give you certain ideas. Okay? Hope you guys are very brilliant, clever guys. Work hard from the beginning. Otherwise, you will find difficult when you will do your assignment or your exams. Now see the termination of a contract. I believe that you got an idea what is contract. Now see the term termination. Termination means what? See, there is a relationship going on. This is the start point. This is the end point. From here, if you will start, in this point we have to stop. The stopping point means termination. Okay? We'll say, we defined earlier that for 5 years, it must continue. But due to certain reasons, if one of the party, I told that there must be two parties in a contract, A and B. Fine. One of them willing to enter with this contract before 5 years, they can terminate. Hope you got this point as well. All right. Termination means ending up with something. These are the elements or the features or the grounds where we can end up the contract. Termination of an offer, termination of a contract, performance, breach of contract, frustration. This is frustration, man. I don't know why there is a typing mistake. It is frustration and an agreement. Okay. We'll discuss about the termination of an offer. Termination of an offer means what? People, you guys have to understand that I already told offering. See the word offering. There is a boss called A. Okay. There is an employee called B. B wants to get a job from A. That is his expectation, not an offer. Offer means a party must give something to somebody. Here, A will provide a job to B. That is offer. Understood? See, A will offer a job to B. Students got the point? People, tell me. Anybody? Did you understand this stage, the first stage? People, tell me soon. Yes, sir. Thank you so much. Okay. Now, when offer can be terminated? See, oh my God, this is A man. Okay. A will offer a job to B. If somebody is offering something, the guy must accept this. Then a contract will be validated. But there are some exceptional situations where offer itself will be invalidated in the beginning stage. We'll say in a contract, you guys are management students. Hope that you know about the employment. Now, all of you, how many participants? 24. There were 30 now, 25, I don't know. Okay. Now, all of you, just imagine that you guys are a boss. I'm an employee. If you are giving me a job, that means an offer, you will tell me, Mr. Udayashree, I am offering you a job. You have to join on this day. Today 19th, Sunday, tomorrow is a working day. We'll tell Mr. Udayashree, tomorrow 20th of May, you must join in our company tomorrow. That is the condition. That is the lapse. So, that is lapse. See, there is condition that tells me to join on 20th of May. They are telling me to join. That is fine. If I am not joining, there is a lapse of time. See, offer can be invalidated. Offer, see, lapse, an offer may be lapsed before acceptance. Before B accepting that he will come on 20th, it can be invalidated if he doesn't reply soon as possible to the boss. Okay, boss, I will join. If B will not tell within a reasonable time, A will go to another person, maybe C or D. That means A is a boy. No, A is a girl. B is a boy. We'll say B proposed A. A is telling, okay, I accepted, me to love you. If B doesn't care, what A will go? A will go to other options. Simple in our life. That is contract of employment as well. There is an offer that A providing a job to B, but A is telling join on 20th. If B doesn't reply, if doesn't give a positive reply to A, and time sorry, and time runs out, what will happen? There will be a lapse, delay, that will invalidate the offer. Okay. Now, rejection. What is rejection? In normal term, rejection means rejection. Simple. A proposing B, saying, would you like to marry me? B if says no, that is rejection. There is an offer, other party not accepting, rejecting. At the time it will be invalidated. Finally, revocation. What is revocation? What is revocation? Revocation also rejection like thing that other party will not accept, but there is a condition that must be communicated effectively. Okay, for an example, A offering a job to B. A must inform B that okay, I am offering a job, you can join on this day. And mere statement is not relevant. It must be communicated. We'll say boss A tells to one of his employee in his company or in his office tell B to join. And that message, if not delivered to B or not anybody communicated B to join on the day, B will not communicate, B will not come to job because B doesn't know that the company accepted him. So there must be a effective communication. The company must send a mail, phone call, anything in any mode of communication. Message must be passed from the offeror to offeree in an effective manner. At the same time, the revocation as well must be communicated in that way. For an example, B says, "Yes, boss, I'm happy." That is the acceptance. If B says, "Mr. Boss, I'm not happy with the job, I'm not coming." B calls and tells A is effective communication. If B sends a mail, that is effective communication. Posting a letter is effective communication. We'll say if B thinking of like that or tells to his friends, that is ineffective because those people are not the party to the contract, as well as if the message is not communicated to the boss from the B, that is ineffective. Who knows whether B accepted or rejected or revoked the contract? Therefore, there must be an effective communication. Clear? Clear? Anybody tell me something? If you are not clear with this, you will find difficult. That's what I'm very slowly, clearly teaching you the relevant points. What do you think? Am I clear? Tell me, Malshi or anybody, did you get the point up to now? Very nice. Thank you so much. If you are clear, that's good. Now we saw what is a contract, how we are entering into a contract, and how we terminating by rejecting an offer like. Now the second part, discharging of a contract. Discharging, what is discharging? See, in the early example, we discussed that termination of an offer. Termination offer means what? Before entering into a contract, A is offering something. If B accepts that only, there is a contract. A relationship starts. A proposing B. A proposing B. If B accepts the love only, there will be a relationship. Otherwise, heartbroken. No relationship. From that moment, A is nobody to B, B is nobody to A. But if there is a valid offer without termination, if they accept the offer, there will be a contract. So A gives a job to B, B accepted, communicated effectively. From that moment, A and B will start a relationship called employer-employee. Their relationship will be communicated or regulated, will be monitored under contract of employment. Okay, their relationship will be regulated under this. At the moment, if they want to, we use that color, we'll use another color. Okay, at the moment, if they want to terminate a contract, what will happen? That means there is a valid contract. Now they want to discharge this contract. What will they do? We'll say A married B. Now they are husband and wife. They are regulating under law because they are registered their marriage, registered marriage. Now they want a divorce. Now they want divorce. If they want divorce, sorry for this writing, I have no way. If they want divorce, what will happen? That is the point. Now we are going to learn under termination of contract. Okay, guys. See, termination of a contract. Performance. What is performance? See, boss A gave job to B. A says B to do certain task. If B completed each and every task, okay, if B completed each and every task, there is no anything between them because A completed whatever B completed whatever A said, and A is satisfied with the work of B, and the obligations are fulfilled. If the obligations are fulfilled, the contract totally performed. If a contract is performed, think we want something. We are going to a shop or restaurant. We are hungry, or we are thirsty, or just we want to drink something. At the time, we are ordering something, any meals, or any drink, anything we are doing, and a cake. We are ordering a cake. They prepared according to our descriptions and they delivered. We are paying. At the moment, the contract is finished with that restaurant. Hope you got the point. Just we are going to a shop or to a restaurant. We are ordering something. They are preparing and they delivered. We paid. At the moment, the contractual obligations are performed. So there is no any way to continue that contract. In this point, we are discharging such contract. Understood? Anybody? Tell me. Anybody? Hirosha, Hiruni, Javardhana, anybody? Did you get the point? Hope you got. Now, breach. See, in the performance point, in performance, we performed. In breach, we are not performing. That is the difference. There are certain terms and conditions, obligations in a contract. B completed 1, 2, 3, did not complete last 2, or A told B to manufacture a car. A tells B to manufacture a car. This is normally a car. Okay. But B manufactured only 2 tires, not a car. After a long time, it took, we'll say, at least 1 year, but he prepared only 2 tires. What can he do with these 2 tires? Nothing. So, B did not perform the contract. This is a breach of contract. Or A told B to prepare a sports car, but B prepared a car which is just suitable for taxi. Is it good to A to continue with B? No. In this place, breach of contract. Simply understand, breach of contract means one of the party did not perform. Performing means did something. Breach means did not do something according to the terms and conditions of the contract. So in these two places, we can discharge. Finally, agreement. What is that agreement? Contract, you guys have to understand, contract itself is a what is this? Contract itself is a agreement. I need whiteboard. Now many settings are changed. It's okay. Okay. Guys, understand? Contract itself is an agreement, but inside the agreement, they are telling that we can discharge contract using an agreement. What is that? How can this possible? Just go and see. Here, this is very little complicated, but fine. Agreement means one person telling something to another person, that guy, second person, accepting. We'll say A and B are in a contract, in a relationship. They want to discharge. At this point, what will happen? There is no any breach. There is no any wrong. Just they want to stop this contract. We'll see. This is Pepsi company. Okay. Pepsi company entering into a contract with company X. In this point, Pepsi wants to terminate the contract with company X. There is no any wrong. Just they can enter into another agreement saying these things happened. I'm not happy with you. I just want to do this business with another guy. So bilaterally, I am terminating. You accept. This is the point. A simple explanation is, a simple idea is, a simple idea is A is in a relationship with B. A is in a relationship with B. Okay. We'll put art. Love nahi. Okay. एक art come up में. A is in a relationship with B. Now, B cheated A. A found. Okay. A found. Now, A wants a breakup. What will she do or he will do? Will talk to other buddy, will scold, will send the evidences, and finally they will break up. That is the agreement. But sometimes here there may be disagreements. But this is the agreement that whatever A says, B will agree. Whatever B says, A will agree. That is bilateral discharge. Both of them happily will discharge from the obligations of a contract. Understood? Guys, understood? Tell me quickly. Understood somebody? If it is not clear, tell me, I will explain you. Okay, somebody telling that they got. So I hope that others also got agreement. Now, frustration. What is frustration? Here the spelling is very good in your course book, but in other places that's wrong. Frustration. Frustration means something just you think that something is happening beyond control. Beyond control means we can't control. The government can control. Oh, a natural disaster. We'll say, I'm entering into a contract with a fisherman to do certain things. Tomorrow near beach or in the sea, but it's raining heavily. I can't go. And police officers, news, everywhere there is a alert not to go to sea. What can I do? Can I blame the fisherman? Or can I sue him in the court saying that he breached the contract? Can't. In this kind of situations, we cannot blame each other. We all can remember the pandemic period, Corona, COVID-19 period, how frustrated we were. Still, the effect is in this country. We were hungry. We were angry with people. We shouted. Many annoyed. At the time, many businesses went wrong. Many plans did not happen in the way how we want. That was frustrated. At the time, we didn't have any chance or anything to blame anybody because we all understand that was a situation which was beyond our control. Tsunami, any accident, something is happening like that. That is frustration. We can do nothing. We can't blame anybody. Obligations will be stopped. We know that entering into a contract, there is a contract, very contract, written one. Everybody, the parties to the contract have obligations towards the contract because we ensured everything. But something is happening, what we not planned, we can do nothing at the time. It will happen in the life as well. Just what we will do, we can't blame anybody. We'll let things to happen. That will happen in law as well, in law of contract as well. Understood? Understood? Somebody told something I didn't hear. Did you tell anything? I can't hear you. Hello?
That is understood, sir.
Yeah, thank you. Thank you so much. Now I'm going to give you a brief idea. I stopped screen sharing. Still sharing. Can you see something? Your screen is still, yes. Stop sharing here. Okay. Okay. I believe that you all understand Unit 9, new whiteboard. And the sticker, what is this? Going to place a sticker. Okay, I will. Thank you. It's not going, man. Now, still load. What is this? No. No, okay. Okay. Can you see my whiteboard, people? Tell me soon. Lahiro, people are running over there. Hey, Minuri, don't fight anything. Who's that? Now Malchi. Hey, people, stop writing. Okay, see what we learned. There is a contract. We'll see. There is a document. Can you see? Don't message me, man. There are so many messages. Yes, sir. Yes, sir. Yes, sir. I am confused. Can anybody tell me whether you can see the board or not? Anybody? Randomly? Tanya, can you tell me? Yes, sir. Manshi. A good girl. Boy or girl, someone. Yeah. Hey, people, you guys are writing a lot here. Don't. Tick, tick. Okay. तेरा बस लम्बा हो गया नहीं? Don't write anything. Okay. Here, see, it's a contract. It's a contract. There are some details about the company, whatever, whatever, blah, 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 blah. There are some obligations. Tick, tick, tick. Okay. Both place their signature. Okay. This is a contract. Now see, Hiruni, don't write. Take off your hands from the board. Let me to explain quickly. This is a contract. There are some obligations. See the highlighted part. There are some obligations. The parties are A and B. A and B are parties. A gives some obligations, B accepted. B gives some obligations or any descriptions, A also agreed. Upon that agreement, they created a contract. So A signed, B signed. This is a contract. In case if B does not like to accept whatever said by B, he won't sign. Okay. At the time, A did not accept the offer of A. B did not accept the offer of A. What happened at this time? Contract will be terminated. We'll say in case A accepted. Okay, he's telling, oh, yes, boss. Oh, yes, Macha, I will do whatever you are telling. He accepted. So B also signed. Now there are some obligations to be performed. In the future, A or B must do these things. Understood? If they performed, that means if they completed each and every task, contract will be terminated. Performed. If they did not perform, anybody will get angry. If A doesn't do, A will get angry. If A doesn't do, B will get angry. There will be a disappointment. They will terminate the contract. Frustration. Frustration means COVID, tsunami, anything is happening beyond our control. We'll see. Udayashree is contracting with somebody in yourself from this group. Udayashree suddenly disappeared. Cannot be found in the future days. Went somewhere. Or died. Whatever happened. What will you do? That is a frustration. At that point, you cannot perform the contract. So only the choice is termination, discharging. Finally, agreement. A and B already in a contract, but it is not working. So A or B, anybody will propose an agreement for both of them. Together will create an agreement. Then they will tell, we'll stop at this moment. We'll stop at this moment. Like breakup, divorce, anything, settlement, going for a settlement. You have due to me, you pay. You have due to me, you pay. That's all. We don't want to continue these obligations or contract anymore. I'm fed up with you. Oh, I'm happy whatever you have done right up to now, but I have another person to do this better. I would like to go with that guy. You are not suitable to my company, so here we will end up this relationship. Please, this is the agreement. You sign, I will sign. We'll finish this off. That is the agreement. Up to now, that's all we have learned. Got my point? Am I clear? Tell me anybody. Tell me anybody. Udeshika, who's that? Madhu, Sashini, Asindu, anybody? Drop me a message at least. Now, if you guys got, yes sir, Jani. Thank you, Jani. Now clear. Give me a second. Participants. Okay. Now we completed one unit. There is another unit. I give you 5 minutes break. Now time is 2:30 nearly. Come here 2:35. Don't leave the meeting. Stay just 5 minutes. Just 5 minutes. I will start exactly at 2:35. Just 5 minutes break. Hello. People are there, right? Now we'll discuss about assignment paper. Are you all there? Hello. Who is Jayavardhan? So happy there in the chat box. We'll be covering all the units. Not exactly all the units. 9, 10, then 1 to 5 revision. Then some people, somebody asked me to explain about a exam paper or an assignment question. So I will discuss about how to answer it. Now see, I'm going to discuss a assignment paper. Is it okay? Hello. If you guys want tell me something, I will stop sharing this. See, what is the law? And the importance or the advantages that a business students can learn. Here, you have to understand there are two questions, distinctions. There are some distinctions. You have to understand that first. See, what is the law? Law means set of rules or something that is regulating the behavior of people. You have to understand, you have to have an idea what is law is about. I told you, if your father or mother ordering you to do something, you have to do, because we have to obey to our parents. If you will kill somebody, the state, the government, or the court will punish you. So we have fear of punishment. If you will do something good, people will appreciate. If you will do something wrong, the same people will blame you. If you will commit an offense, will say you killed somebody, you stolen something from somebody, or you caused injury to anybody, inflicted an injury to somebody, what will happen? The court will punish you. We, all of us, including myself, even the senior lawyers, judges, have reasonable fear to law that if we will do something wrong, the law will punish us. Because of that fear, we are obeying to rules that made by the sovereign body, legislation. Hope that you guys have some idea regarding the previous topics. Next week also we will have one session. At the time I will explain furthermore. Up to now that is important. Now we are going to see how to answer. So you have to give an introduction to law. Then you have to understand as a business student, what are the advantages learning law? In previous occasions, I used to see some papers. There I saw that people are writing like, I'm a boss, like this in this theme, not exactly in these words. Very properly they designed their answer, but what they wrote was, I am a boss, I have leadership quality, I have management quality. We are not asking that people. Dear students, understand. This is subject called law. By learning law, what are the outputs that you can bring out as a business student? So your answer must connect to business studies, but you have to give preference to law, because the question is not about the business or business student. The question is very clear, very certain. What are the advantages of learning law? By learning law, you will understand what is law first. What are the phases of law? The good, bad thing, punishments, or the regulations. We'll see. As a business student, you know that you will enter into a contract with your boss, or you will be a boss. You will call other people to enter a contract with you called contract of employment. All of these times, you can't design a contract. We'll see, for an example, this is your Open University paper. See, they used a logo, a company logo. There are some descriptions. What is this about? There are some serial numbers that allocated to subjects and deadline. This paper, see, there are some descriptions, the conditions. You are agreeing with all of these things. Then only you are going to the main task, that you will write two answers to two questions. Okay, so you have to plan your answer. Now see, I'm going to write an answer just for an example, not exactly, mere idea that what comes to my mind. What is law? Say law is What is happening? Answer. Yeah. Here. I have to start from here. Yes. Okay. Law is a set of rules that governs the behavior of people. I'm just telling like this. I can elaborate a lot, but this is enough. Law comes from authorized body, so breach or violation of law leads to punishment. We'll say like that. This is just an introduction. As a business student, learning law gives wings like drinking. Remember that. Don't write like that. Learning law gives many ideas about law and its performance in society. We are getting idea about trade law, company law. You have to explain what is trade law, what is company law, okay? What is intellectual property law? And you have to elaborate what are the things that connect to your subject, law of contract. Law of contract regarding labor rights, regarding court system. So you will come to know that where you want to lodge a complaint, remedies. That means if there is any violation, you have to get some remedy. We'll see. And I punched on your face. You got injured. You are suing me in the court. What can I do? I can give you compensation. I can look after your medical expenses. So that kind of things you have to write there. Then conclusion. Remember, every in each and every question there must be a conclusion. Here say law is whatever any like love letter. You tell something whatever comes to your mind regard, but connect to that with subject. Law is everywhere. This is just normal, very typical answer that anybody can write. So just anybody can write in that manner only approaching you. You also get idea that what you can write. Conclusion: law is everywhere. Learning law gave me confidence, though though I am though a business student, I connected law with my subject, which is helpful for my future business achievements. Now it is very easy. See, there is a question. Now we are reading the question. Then we understood. There are two, not one question. There are two questions. One and here two. Okay. Then we understood that question is not about business student. The question is, what are the advantages of learning law? Okay, learning law. So what can I do with law? And take the question. Now we have to give an explanation to law මේක පොඩ්ඩක් ඩෙවලොප් කරන්න මේක මදි තව පොඩ්ඩක් ඩෙවලොප් කරන්න කරපු ගම මෙන්න මේ ටික එක්ස්ප්ලেইন කළා කන්ක්ලූෂන් එකට ගියා ඕකේ මට මොකක් හරි අදහස් තියෙනවා අයිඩියා ආවා මෙන්න මේව ලිව්වම අන්න ළමයි ඕගොල්ලෝගේ ප්‍රශ්න මේ the answer is completed තේරුණාද anybody tell me message දාන්න එපා ටිකක් අමාරුයි මට කඩරලා කියන්න unmute කරලා තේරුණාද
Yes.
okay ඒක useful ද දැන් idea එකක් ආවද දැන් දෙවෙනි ප්‍රශ්න discuss offer invitation to treat acceptance මේක අපි ලබන සතියේ බලමු okay දැන් තේරුණාද මගෙන් කවුද අහලා තිබ්බේ මේ ආන්සර් කරන්න විදිය පොඩ්ඩක් කියලා දෙන්න කියලා guide us to write ජයනි ජයනි කියන්න තේරුණාද ජයනි
Yes, sir.
okay did you get the point now
Yeah.
we will discuss yeah okay okay thank you yeah now we'll go to the second chapter second unit exactly මේ ක්‍රමය හොඳයිද ප්‍රශ්න තේ වෙලාවම කියලා දෙන එක හොඳයිනේ රිවිෂන් කියලා ත වෙනම අරන් බය කරන්න නැතුව නැද්ද okay yes I am okay then unit 10 when දැන් අපි දන්නවා already we studied that A entering into a contract with B so now they are fulfilling the obligations that they agreed that මම මේක කරන්න ඔබ මේක කරපන් we will do this and finally we'll finish this work make a contract ඉවර වෙන තැන but understand if somebody will not do a important condition that will known as breach okay violation already we discussed what is law at the time I told you that even judges lawyers ministers even our president is scared of punishment if we will violate law if we will do something wrong there will be a punishment the same thing applicable to law of contract as well in this place you have to understand that there is a breach of contract the non-breaching party so you have to understand there are two things okay first of all there is a contract C is a contract there is a contract written contract there are two parties A B A and B there are two parties B violated A did not so he is the breaching party the party who breached A is non-breaching party A told B to give 500 rupees for the work done A did something that B wanted for that B asked 500 rupees we'll say B ordered kottu roti from A prepared that kottu තියෙන කුණු ටික දාලා අදලා රසට ආරි බීට දුන්නා මෙන්න කොත්තු කියලා. මේකට රුපියල් 500ක් ඉල්ලනවා. He asked, hey, first of all, tell me, is there any Tamil speaking student?
Yeah, sir.
Can you understand Sinhala?
Little bit.
Okay, give me some time. I will explain in Tamil as well. This is very important part, so I will tell in your mother tongue. That will be very helpful to you. Here, now Sinhala students are on. There is a contract. Parties are A and B. A කඩේ මුදලාලි hotel තියාගෙන ඉන්න කෙනෙක්. B ordered කොත්තු. A කොත්තු ලේස්ති කරලා B ට දුන්නා 500ක් කියලා කියනවා. B did not pay. Now to Tamil students, தமிழ் பிள்ளைகள் கேளுங்க. ஒரு கான்ட்ராக்ட் இருக்கு எழுத்து மூலமாக. அந்த கான்ட்ராக்ட் என்னன்னு கேட்டா ஒரு ரெஸ்டாரண்ட்ல A தான் ரெஸ்டாரண்ட் வச்சிருக்காரு. B A கிட்ட கொத்து கேக்குறாரு, ஒரு பாட்டில் கொத்து. A ரெடி பண்ண பிறகு அதுக்கு 500ன்னு சொல்றாரு. B பே பண்ணல. இது breach of contract. ළමා මේකට කියන්නේ අපි breach of contract කියලා. So the party who did not breach the contract is non-breaching party. Always මතක තියාගන්න. Remember, ஞாபகத்துல வச்சுக்கொள்ளுங்க. Law helps. Remember one thing. Law helps only innocent. Law requires the party who needs remedy to be clean hand. ඒ කියන්නේ වැරදක් කරපු නැති එක්කෙනෙක්ට තමයි remedy තියන්නේ. හරිද? Law helps only innocent. The person who did not do any wrong can get help from law. That is called remedy. If a party need any remedy කියන්නේ අපි බලමු මොකද කියලා. He must be clean hand. Clean hand කියන්නේ කිසි වැරදක් කරපු නැති කෙනෙක්. ஒரு பிழையும் செய்யாத ஒரு மனுஷனுக்கு தான் சட்டத்தின் மூலமாக ரெமெடி கிடைக்கும். தேவனாத? Did you get the idea? Did you get the idea? Hope you got. किसी का अपना है. Can't waste my time. Go moving. Okay. Now we got that there is a contract. There are two parties. There is a contract. There is a breach. So what the non-breaching party can do if other party is breaching? දැනට මතක තියාගන්න. A වැරදක් කරපු නැති කෙනෙක්, B වැරදක් කරපු කෙනෙක්. When there is a contract of breach, we can get some common law remedies. Common law remedies කියන්නේ ළමයි that then principle දෙකක් මම කිව්වේ, two principles that I told you now. The party who is expecting any remedy must come with clean hand. Law helps only innocent. These are some common law principles. So what is common law? What is common law? Common law means all of us know that once upon a time we were ruled by British. British had a parliament, but they did not written law to anything. So the judges who are experts in law analyzed the circumstances or the problems that are arising in front of them. There are some rules and regulations that are written in a limited journal, in a limited point. But in one extent, judges, the courts, saw that out of the box problems are coming. As a solution to these all problems, there are nothing. At that point, judges vested power. Judges had power to decide the matters. ප්‍රශ්නයක් එනවා. ඒකට solution විසඳුම ගන්න. There were no any arrangements. At the time, judges had power to decide in their discretion. So, they considered some things that is just and equitable remedies. For an example, the party who is seeking any remedy must come with clean hand. Such kind of common law principles entertained into contract law as well. හරිද? Common law remedies කියලා කිව්වම අන්න බලන්න. Generally monetary damages. That means A prepared kottu. A prepared kottu delivered to B. B did not pay. Here A is suing B. So කියන්නේ මොකද්ද? උසාවියේ complaint කරනවා. Sue means A B கோர்ட்ல கம்ப்ளைண்ட் ஒன்று கொடுத்து இவனை குற்றவாளியை நிப்பாட்டுறதுக்கு தான் நம்ம சொல்லுவோம் சூன்னு சொல்லி. எஸ் யூ இ. சரியா? A sues B. At this point, A will argue that he ordered kottu, I put some roti, sausages, chicken, whatever, blah, 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 come, gas, everything. The court will consider all of these matters and will tell B to pay. Because of you, A met many losses. You must mitigate it. You must pay. The party who is wrong must give remedy to the innocent party. So you pay not 500, 5,000. Because of you, he came to courts. He lost his business. He lost his business. There were many problems because of you. Because of 500 rupees, he spent money, time, energy, everything. This situation is very unfair to A because A is innocent. A didn't do anything. Why he should suffer? So, court tells B, Mr. B, you are wrong, guy. You cheated A without paying. Because of you, A came to court. He spent time, energy, he wasted everything. Whenever he is coming to the court, he did not run his business. So, Mr. B, you pay A 5,000 rupees. This is common law remedy. That means mitigating, trying to mitigate, trying to shape කරන්නදනවා. நாங்க கொஞ்சம் மனிதாபிமானத்தோட ஷேப் பண்ணி ஒரு ப்ராப்ளம் முடிக்க பார்க்குறோம். That is common law remedy. Damages is what? මෙතනත් අපි සල්ලි තමයි ගෙවන්නේ. But what we will do is like passing insurance means A broke. I think I can type there. See, A broke B's car damaged. To repair car, B should pay A the amount or the expenses. මේක තේරුණාද? මෙන්න බලන්න damage කියන එච්චරයි. A නිසා B ගේ කා කැඩුණා. A செய்த பிழையால B ட கார் உடையுது. அந்த உடைஞ்ச காரை செய்யறதுக்காக A should A should pay B. அந்த உடைஞ்ச காரை சரி செய்யறதுக்காக செலவாகும் தொகையை A Bக்கு கொடுக்கிறது damages. ළමයි A Bගේ කාර් එක කැඩුවා. දැන් කාර් කැඩිලා තියෙනවා. මේ කාර් එක හදන්න A Bට සල්ලි ගෙවන්න ඕනේ. ඒකට තමයි කියන්නේ අපි ඉන්ෂුරන්ස් කියලා. Okay, insurance damages. මෙන්න මේ remoteness of damages is also same. Just you read and get idea. It is very easy that what is telling that damages given on the net, whether he have to pay the damages or not. It is very remote. Remote means there is no any time to pay, no any way to pay damages because of certain reasons. It is very easy that paying damage is fine, but in certain circumstances, the court will ask question: is there any situations to pay damages? Because both of the parties may have any problems or any issues or any wrongs. At the time, what will happen? See, when a client for damage is made, to what extent can the demand be claimed? Is damage claimed too remote? A consequence of breach. Maybe analyze karala. Coming to the determination is discussed in that part. Equitable remedy means principle. That means equitable remedy means what? Compensation, paying damages, equity. Equity. The person who is coming to court in order to get some help from the court must come with clean hand. That means equitable remedy. Hari varadi balala, hari genata, we will help. Sari pilla பார்த்து உண்மையாலுமே இன்னசென்ட் சரி செய்த ஒரு மனுஷனுக்கு நாங்க ஹெல்ப் பண்ணுவோமா இருந்தா that is equitable remedy. அதுதான் ஐடியா. ஐடியா අර අවබෝධය ඇති ළමයි කටපාඩම් කරගෙන යන්න ඕනේ මේවා. You have to get some idea what all of these things. You don't want to memorize each and every word because we are not dictating in the exam paper or question paper. We are going to examine your understanding. If you got the point, if you will explain exactly what you understood, the concept, you will get full marks. Then specific performance will say specific. See, specific performance means there is a contract. The contract is telling A to build a house. That is specific performance. If A did not do anything or did not construct the building, the court will tell the constructor to build the house because that is a specific performance under that contract. Specific performance. Specifically do that. Injunction is something different. Injunction is very interesting as well. Now I am stop sharing this. Now I want a whiteboard. New whiteboard, yes, new whiteboard. It's loading, man. Okay. Injunction. Lamai, people, see, injunction means understand one thing. Something is happening, the court will put a barrier. This is injunction. Another. Jayavardhana, who's that? Don't write anything. Can't waste time. People, if you guys are finding difficult because of rain, don't worry. We are recording. I will update. You can listen again. Don't worry, don't worry. Now just understand whatever we are discussing here. That's fine. So now where is that? You do not. Right. Injunction means something is happening, the court will put a barrier. You can't go from here. We'll say something like this. Person A, there is a person called A, is doing something wrong. Best example is like this. Person A, B entered into a contract to cultivate, to create a paddy, to cultivate paddy. This is the contract. But A tells B to make a paddy field. This is the contract. But B erected what? But B erected a building here. B at once constructing a building. Foundation डाले हो रहा है. B, in order to do a hotel, he is constructing. This is his plan. Once B came to know, B is asking, A is asking B, what the hell is this man? I told you to cultivate here. Why are you constructing? This is the problem between them. B is telling, no, I got this land for lease for 99 years. Oh, anything, for 5 years, or anything. For that period, this is mine. This is fundamental breach of contract. Here, A can sue B in the court, get an injunction order not to construct. Okay. If this is confusing, see, a train is going on. A train is going. Okay. When a train is going, a barrier will be put, stop barrier, two sides of people to stop until train passes that places. Once train goes, the barriers will be taken off and the vehicles will be allowed to two sides. Drive a truck, but train, when train goes, we will be allowed to do. The same thing will happen here also, Lamai. Apart from the contract, we are doing something. Apart from the contract, we are doing something. One party is telling other party to stop. Nikan cutting stop kiyala kivuvama, that will not happen. Why moolamaga nirtha sonna nadakadu? Because of that, people will go to the court. Then court will tell until judgment comes, stop working on this place. Don't do anything here. Don't do apart from the obligations of contract. That is injunction. Once case is closed, case your own injunction order, based interim injunction. There are two parts: interim injunction and final injunction. Interim injunction in the sense, the interim injunction in the sense where the court will order a party wrongdoer or anything, the party not to continue the work hereafter. Interim injunction, temporary injunction. Once the alleged fact is proven, the court will order permanent injunction order. Just you remember, that's all. That's all you have to remember. Very easy and up. ரொம்ப யோசிக்க தேவையில்ல, இந்த ஐடியா இருந்தாலே போதும். Okay, people got my point? Did you guys understand? Tell me quickly.
Yes,
It is understood.
Yeah. Now take 7 minutes break, like come at 2:20. Remember, just you organize your mind, work accordingly. Now, after that, we will make a revision of unit 1 to 5. Block 1. We are going to do a revision of 1 to 5. That will be very helpful for you guys. Take 7 minutes break and refresh your mind. Do something and come at 3:20. I will start at 3:20 exactly to come soon. Okay, guys, are you clear with the part we have done? If you're okay with all, I can go for revision.
Excuse me, sir. Can you please explain the question number 3 of our CAT paper?
Question number 3. Can you share, please?
I only have the physical paper.
Can you take a picture and WhatsApp
I'll try.
me or in the chat box? This is my number. In the chat box, I send my number. Try to share. Try to share on WhatsApp or in the chat box. And we will do that in the sometime later in this session. Now we'll go for the revision. Can you see my screen, the block 1, introduction to law and contract? Can you see, guys? Visible? Yes, visible. Thank you. Now we are going to discuss these 5 topics. Unit 1, 2, 3, 4, 5. First of all, the nature and functions of law. Nature and functions of law is simply what we discussed. What is law? Under that, we told what is law, what are the importance, and functions of law means, remember, law can regulate the external behavior of people, not the internal things. Here, Jayane, that is a student called Jayane. I'm trying to steal something from Jayane. That is, I am thinking. That is internal capacity of mind. Law doesn't tell of police officers, court, ministers, judges. No authority can stop me from thinking like that things. I can dream, I can plan anything that is inside my mind, but I can't execute that. I can, but if I will execute, if police officers catch me, they will put me behind the bar. They will punish. So, law is controlling, monitoring, regulating our external behaviors, not the internal. factors. That is the main function of law. Another function of law is law ensures, enhances just and fair society. What is that? I am thinking that nobody can beat me, nobody can slap me, nobody can steal my property because I gained it, I earned it. If I am thinking like that, as a reasonable person, I have to treat others also in the same manner. For an example, I am thinking that nobody can steal my phone. If so, I have to think that I can't steal property of others as well. If I'm thinking that others cannot harm me, I can't harm others. This is just manner. Ordered society means lawfully happening everything. In Colombo or in anywhere in the main road, we are driving a car, a motorbike, anything. A red light is blinking. What will we do? We will stop our vehicle and stay until green light blinks, which means that law permits us to go. This is a situation in the daytime. What will happen in the night? We'll imagine in a junction, there is color light, but no police office, no CCTV. Nobody will catch me if I will pass the road, if I will breach the law. But a good citizen will do stop there, like he does in the daytime as well. In the night also, even though in the absence of any authority, in the absence of any police officer, in the absence of any CCTV, a good citizen will stop in the midnight as well, in the red signal, and he will go when green light permits. Law creates citizens like this. Law enhances lawful society. This is the main function of law. Nothing else. Law is not rocket science. Law is not magic. It's everything about realistic things. What happens? And law always bringing justice. Law tries to enhance peaceful society. If somebody raping, notorious thief, trying to kill others, trying to steal others' property, if there is nothing to control it, if no authority controls it, what will happen? In the future, everything will be destroyed. Rest, nothing. We can find no peace. So, law creates lawful society, peaceful society. It ensures that the future generation will be happy because law creates good persons today. These are some functions of law. Just understand the subject. Just get some idea. Read much as possible. Passing exam is very easy. Also, applying law in your day-to-day life is easier than passing an exam. Okay, now unit 2. The development of the legal traditions and legal systems. What is that? Development of legal tradition. See the word legal traditions and legal systems. Legal tradition? Tradition means what? Tradition. Legal tradition. These are two distinct words. There are two words. legal, law, and tradition. Law means whatever we understood right now, just we discussed. Tradition means culture, long time practices that we are following many times. Our grandfather followed, father followed, mother followed. Now I am following. In the future, my children will follow and their children. This is tradition something. Tradition of Sinhalese, for an example, Osari. Tradition of Tamils, the sari. Tradition of Muslims, that I don't, I exactly I can't remember the word. The something black color cloth that girls can close their face and go, that one. And tradition of foreigners, the British people, coat and suit like. These are some traditions. For an example, just I'm telling. So here, remember, law and tradition mingles, merges, two different world, two different journals merges in this point. Law connects with tradition. Simply understand law of people, Canadian law, Tesawalamai law, Muslims law. These kind of laws, Mukuwar law. Mukuwar law means the fisherman's law. So what this concept tries to tell is, in the beginning, law was not there. There was tradition. How to marry, how to make babies, how to adopt others' children, how to treat people. Those are tradition. Whatever we practiced from the beginning. By birth, you did not know law, but later you came to know. But tradition, customs, talk to you first. Before you obey to law, you understood or you came to know or you knew that how to obey to the orders, commands of your father, of your mother, of your brother, of your sister, or aunt, anybody, elders. Everything taught us by our tradition, by our customs. We are worshipping our parents because it's our tradition. But law doesn't impose us to try to worship our parent. But law tells not to kill your parent, not kill anybody. Tradition does not permit us to marry our own sister or brother. Tradition doesn't permit us to allow marriage of father and daughter, mother and son. The same thing law also does. That is unnatural things. Thus, that kind of things are happening here. Now, Tesavalamai. That is the law of Jaffna people, Jaffna Tamil people, origins of Tamils, governing the land. That is Tesavalamai. Canadian law, Canadian Sinhalese law. From the beginning, they followed that law. There are some set of rules regulating their marriages, adoptions, inheritance, succession. What is succession? Succession means devolving the property from one person to another person. You are claiming entitlement from your father or mother under Canadian law. It governs under Canadian law. It governs only Sinhalese, Canadian Sinhalese, by birth who born in Kandy in province, and also applicable to other traditions that is in North, read. And Muslims law. Muslim law is applicable only to the Muslims, governs their sectors, and they must be very proud that they have a separate judicial system called quasi court. That is only to Muslims, not to others. So here you have to understand law and tradition mixed in this place It brought a new concept, that is legal tradition. Legal system means what? Law or anything cannot be lived, cannot be left isolated or in a vacuum. Just merely we can't let things to happen. There must be a system, mechanism. In a company, there will be a CEO, the owner, then the management, then employment, underemployment, minor staffs. There is a hierarchy. In legal aspects also, there are some hierarchy. There are some systems that a thing how to happen. For an example, a computer. There are many parts in computer. Mouse, keyboard, RAM, ROM, hard disk, graphic cards, display, whatever, many things are there. All together, one system. The same thing is happening in law as well. There are multiple separate entities, but all together, a system, judicial system, police, military, ministers, judiciary, legislations, executive, these are the systems. How they functions. The constitution law, constitution, ఆంధ్ర వ్యవస్థ அரசியல் யாப்பு, the constitution is the mother document to our country, which is authorizing each and every authority to function. Everything is governing by law. This is legal system. There is a system. Without a system, cannot be. We cannot achieve anything without a system. If something is not organized, we cannot do anything. Without an organized plan, without an organized team, we cannot form a company. We are making a system in order to work with discipline, to do something new, to innovatively do something for the future. That is system. The same thing is happening in law as well. That is legal system. Now, the fundamental principles and concepts of law. Fundamental principles and concepts of law, what is that? Free judiciary. Earlier we learned that in a breach of contract, we will go to court to get some remedy. So the judiciary must be work independently. Executive must work independently. Rule of law. If there is law, we must enhance rule of law. Everything must happen according to law. That is rule of law thing. These kind of principles are very easy to understand. See, there are certain principles like rule of law, judicial independence. You need to give me some time. These are very important, 1 to 5, that repeating in the exams, assignments as well. Question will be designed based on this. You have to be very clear in these things. Surely there will be 2 or 3 questions in 1 to 5 chapters. Understand what are the differences between civil law and criminal law. Here, civil law and criminal law, adversary, inquisitorial, dualism and monism, and here civil and common law, civil and criminal law are very important. Okay, these are the systems. See, there are some different systems: English law, Canadian law, Tesavalame, Roman Dutch law, English law. Those are. Now we are talking not about that. We discuss that is very easy thing. So not much to make hard. See, these are the topic is the fundamentals of law. See, rule of law, equity. Equality, what is that? Here I'm a lecturer, you guys are my students. Tell me who can I call? Dulakshani. Dulakshani. Dulakshani.
Yes, sir.
Yeah, tell me. I'm lecturer, you're my student. Are we equal?
No,
Why?
we should obey you. We should listen you.
Yeah, that is fine. Even I'm listening to you. So you are also listening to me, listening equal. Are we equal?
No, you are a lecturer. You have the power to control us.
Great. That is the point. There is a power. I hold some power towards you. I'm controlling, I'm teaching, and you are learning. So remember, equality before law is fine, but all are not equal. Here I'm lecturer, you are my students. In this place, we are not equal. If we will go to parliament, there are ministers, member of parliament. We are not equal to them. We are going on road. There are pedestrians. There are businessmen. There are a lot of people. We are not equal each other. But remember, before law, we all are equal. Except law permits certain people to enjoy some privileges. For an example, the president has some privileges. We can't just go and meet a president. It's privileged. He has privileged guards to protect him because he's our hero, leader, whatever. He's a privileged one. You can call me Mr. Udeshri, that is fine. But you can't call the president by his name, calling just giving Mr. We have to honor him, honorable president, because he is privileged. So remember, in a normal context, we are equal. We are not equal. We are unequal. We have certain kinds of stages, but before law, we are equal. But even before law, there are some exceptions. It mainly tells that if anybody will do any wrong thing, law will punish. That's all. Equality before law. Separation of power. Already I told you that there are three organs in the governance: judiciary, executive, legislation. Legislations are the persons who are making law. Executive persons are the persons who are executing the law. Executive means ministers, police officers, military, like executive body. Judicial team are like us, the lawyers, judges, who are trying to establish the law in the judiciary, trying to giving interpretation to the law. These, see, we distinguished these three elements. So they have separate functions. We can't just let them all them together to work together. They have separate functions. Law defined what they want to do. They have to do like that. But there must be balances between them. Accountability. Okay. Checks and balances. That means one entity cannot be isolated. Just we are telling that a man cannot live alone in this society. A country cannot survive alone in this world. It needs another country's help. The person must have to access others' help. This is the concept applicable to executive, legislation, judiciary as well. They will work alone their work. They will complete their works. Unnecessarily, a unit cannot interfere into another one's entity. But if somebody working out of the box. If somebody violating the law, one entity will interfere into another one's entity and will make them accountable, answerable. They will ask questions. They will ask justifications. Why you did this? Why you didn't do this? Why there is an omission? Like that, they will ask questions. That is separation of power. Constitutionalism that I told you on the Vivasthavu, Arasiyal Yapu, that is constitution. Everything must be governed by constitution because constitution is the mother document. Based on mother document only, everything is happening. That is constitutionalism. Concept of justice that we discussed. If you will go to court, the innocent must be protected. That is concept of justice. Rights and duties that I told you. If I am supposing to be treated well, if nobody can be stolen property of mine, if nobody can harm me, if nobody can inflict any injury to me, I have to do the same duties towards others. Okay, Jani, Jani, are you
Yes,
there?
sir.
Yes.
Yeah.
I'm expecting that you should give respect to me. If I'm thinking so, you tell, can I slap you? Or can I talk to you like මෙහෙට එන්න එහෙට යන්න කියනට වඩා මේක කරපන් අරක කරපන් කියලා මට කියන්න පුළුවන්ද? Jayani?
No.
Yes, didn't you get my point?
Yeah.
If I wanted to be treated in a proper manner with respect, can I disrespect you?
No.
Yeah, that is this rights and duties. That means I have right to live, but I can't kill anybody. People got that is rights and duties. Whatever rights we have to enjoy that, we have to ensure that we have duties to protect others' rights as well. And now, fundamental and human rights. Fundamental and human rights is very easy. That means fundamental rights are mentioned in Constitution. That I told you there are two elements: Constitution and constitutionalism. Whatever mentioned in Constitution is fundamental rights. You in the internet, you just check Constitution of Sri Lanka and download that and keep that. That is important to everybody. And human rights means by birth we are getting some. Remember only one thing. Fundamental thing is ensured by Constitution. Human rights are the rights that we have by birth. By birth. That's all. Unjust. Make anything up. What is just and equality? That's all these. Okay. Don't buy hard yourself to study law because this is very easy. Unit 4 also we covered legislation, customs, judicial precedent, everything. And court systems. Court system is magistrate law, magistrate. There are two cases basically, criminal law and civil cases. In this hierarchy, you have to understand there is magistrate court. Magistrate court is for civil case. District court is for civil cases. Magistrate, both criminal and civil. Both they come here now, but here magistrate court, criminal, district, civil, high court, criminal, court of appeal. From here, we are making appeals From here, we are going to appeal to Supreme Court, or in Supreme Court, we can file fundamental rights violation cases. මෙන්න මේක විතර වාට ඇති. ලංකාවේ කොච්චර තියෙනවද? Where are they situated? ඕනේ නැහැ. You just read and get idea what are the courts. Magistrate Court, District Court, Court of Appeal, Supreme Court, High Court. These are the names of the courts. Make a ඇති. Then understand what kind of cases that we can file in that cases. Sorry, in that courts. ඒක විතරයි ඇති වාට. Now, alternative dispute resolution mechanisms. It tries to explain you that always you don't want to go to courts. There are some exceptional situations where you can get some justification, just and equitable remedies from outside of the court. For an example, arbitration. Arbitration means retired judges, experts of laws will be there in a panel. It means in a contract, if you and the party to the contract decides that we don't want to go to courts, we just will appoint an arbitration board to get some remedies, it will applicable. You don't want to go to courts, and the decision of arbitration will be the final one. Mediation means just will tell A and B got some injury or any, there was a fight between A and B. Somebody injured, inflicted by a harm. They are going to courts. Sorry, police officer. Police officer will refer a mediation board. Mediation board means some good people will be there who will talk to the persons to the case. A and B are the persons who were engaged into a fight. Mediation board will talk to them. What happened? Why you hit him? Why you slapped him? Why did you scold him with bad words? Why did you get his money? When will you pay? When will you return the money? Like these kind of questions, basic questions will be asked. Let's say a problem with you and your brother, or with you and your sister, or with you and your friend. Always there will be a friend who will mediate between you. In that manner, somebody will talk like that between you. That is the guy mediation. Others ඕන්න නිකන් කියවලා idea ගන්න මෙන්න මේක විතරයි exam එකට එන්නේ. Okay? Understood? Tell me, did you guys get any point? Yes. කියලා දාලා තියෙනවා බලමු. Exam paper. Okay, very good question. Malshi asked that what about the cases? Just I wanted to discuss about this thing. It's good that you mentioned right now. People, all of you understand, this is not business law, business concept, or company matters or anything. This is law. Always we cite to any sections, any law or any cases. That means I'm telling something. To establish that, I must refer to any authority. That is best example is cases. In contract law, for an example, there are some best cases that you have to refer in every aspect, offer and acceptance, everywhere. If you can't refer any cases, you will lose marks. That is obvious. Because we are expecting, we are lawyers, we are law lecturers, we accept some cases from you to be cited. If you will not cite any cases, you will lose your marks. So there are certain units, there are very certain units. Just two cases, at least two cases, you remember the name, what happened, what is the judgment, and try to refer that in the question paper. Or basically, I can't tell the case. You read and understand. It describes everything about offer. In a case, you can understand what is offer, what is acceptance, what is breach of contract, what is remedy. Everything will be discussed in one question, one case. There are cases, very basic cases. Kali Kabul case, for an example, that I told you that I can't tell, but it is very good example. There are other cases as well. Remember at least that kind of cases, at least two cases to all subject. You can refer that in each and every questions and you will get marks. Okay. So can you explain question number 2? Yes, I will come. So do we need to keep in mind all the cases? No, Jani, no, Jani. You don't want to remember all the questions and cases. Remember very few. Apply. You guys, did you notice that I did not refer to any notes very much? By looking at the topic, I explained you a lot. You guys have to understand the topic, the concept. You just keep in your mind what this topic is about and what are the elements. Like that you understand and try to elaborate, explain a lot regarding one topic. Then if you can remember any cases and refer that. But writing case is very good here. That will make you perfect and interesting also. This is very interesting. You don't think that law is just to pass the exam. Until you die, you are going to do something with law. Okay. Now I'm looking at a question. Can you guys see that? Are you all seeing my screen? No. If you won't talk to me, I can do nothing. Because if I will start explaining something, no. लेकिन किया ने मैं मैसेज दाने तो प्रोडक्ट में अनम्यूट कर लगी वो कुछ रहा है इधर wait I will arrange you okay now I'm pretty sure that you are looking at my screen. Number 3, under Roman Dutch law, a promise made intentionally to perform a moral duty, generosity. It also has a much wider meaning than English term consideration. Reasons for promises, also pure moral consideration. Okay. Above statement explain the difference between consideration and justa causa. Who did send this question to me?
I have seen that, sir.
Okay. You tell me the basic idea, at least if you are having problem in this place, you may have any idea of this. Okay. What the idea that you have? What do you think about justa causa? Any idea? Anything? Any ideas? Anybody? Anybody else? Anybody else? என்ன சப்தனானே So do we need to keep notifications? Lama இன்னொரு லீவு நான் போகணும். Hello.
Just because means Roman word about the concentration on some case.
Any other idea? So tell me, what are you looking at my screen? The number 3 question, right?
Yes, sir.
Okay. You have to, if you people listen first. When you will get a question like this, don't panic, first of all. Don't think a lot. The question is, see here, the difference between consideration and justa causa. Okay. You have to need some act, cases, examples, everything. But the main thing is, what is consideration? What is justa causa? That is the case. Okay. Consideration under the contract. Now also the person is not. Who's that? Consideration means, how to tell them, to be simple, in a contract. Okay. Earlier we discussed that B is going to A's restaurant, ordering kottu. There, he is paying money. That is consideration. That means, if you will do this, I will pay. So monetary value, salary, money is consideration. Justa causa means lawful just and cause. Justa causa is a Latin word. See, just, J-U-S-T, just. Just கேன சாதாரண சாதாரண ரொம்பவும் ஒரு நல்ல விதமான சாதாரண தமிழை சாதாரணமான ground. சாதாரண causa means a ground or reason, anything. So contract law is telling, to be a valid contract, there must be a consideration. That means, if you are buying a car, you must pay. If you are buying a laptop, you have to pay by money, salary, give money to do something. That is consideration. Justa causa is telling, to create a contract, if there is a reasonable ground, that is fair. But practically, that is not the case right now. Because without money, we can do nothing. මේ දෙකම theory ප්‍රශ්න. දැන් consideration ට අදාළ section cases කියන්නම ඕනේ. just cause වලට කියන්න ඕනේ. More than that, මේ දෙකටම definition දෙන්න ඕනේ ඔයා. නැත්නම් no marks will be given. Okay? So that is the one thing. කවුද හැවුවේ මේ cases ඕනේද law ඕනේද කියලා? අන්න that is the example. Now, this problem I discussed, right? Not yet. If not discussed, I will discuss right now. Wait, give me a second. I was listening or sleeping. Hello. Anybody? Any subject? What to do? Pass when you pay Netang. Degree am bellene. Net. My kata net. Now, can you see the screen? Message done.
Yes, sir.
Okay, thank you. Love has different meanings in different places. Society, period. Agree. This is the question. For the first time, we discussed at the time, there was a question, what is law? Why business student need law? Here, there, I gave you a definition and I told you to explain something about law. That is the key answer to here. Now, what are the differences between civil law and criminal law? Civil law and criminal law. Both are law. Okay. Headway. It distinguishing behaviors. Criminal means injury anything. That means any wrong thing happens with actus rea and mens rea. That means criminal law means there is an idea and unlawful idea. It was executed. I want to rape that girl and I'm thinking. Then I executed. I want to kill him. I have an idea, plan, then I executed. Those kind of things are coming under criminal law. Breach of contract, misappropriation of property, criminal trespass, like that. Civil law means like contract law, divorce case. Here, only the actus rea is there. That is fine. You have to distinguish. Here you have to give explanation what is civil law, what is criminal law. Okay. Then in this kind of questions, try to give your own examples. Like, see, for an example, divorce case. Divorce case is uh, civil law. Civil law means it is between two individuals. And make a isra pauchikanda. Civil law is between two individuals, but criminal law means between individual and state government. In civil law, we can get some remedies, equitable remedies, damages, consideration. Criminal law always prefer punishment. And even very simple explanation do not get. මේ වගේ ප්‍රශ්න දෙකටම try to go with your own answer. මේ වගේ theory අනිවාර්යෙන් repeat වෙන්න පුළුවන්. මෙන්න මේක කොහොමද? What is law? Why business students needs law? Law what is doing in the what are the functions of law? මෙන්න මේවා හැමදාම අහන්න ප්‍රශ්න. ඕවට you be ready and go. That is helpful. Then මෙන්න මේක. You have to understand. I told you, if you get any idea about court hierarchy only, you can answer them. We'll say, husband and wife, married people want a divorce. Divorce case is going to district court. Husband killed wife, going to high court. A stolen something from C. This case is going to magistrate court. So these are theory. In the book, you read and understand these all of things and take some short notes. That is very useful. Otherwise, you can't survive. And already I shared my phone number. Now also I'm sharing. Okay. Make sure to form a WhatsApp group and add me to. And if you have mm, any clarifications, please text me. මේ මොකද no කියලා දාලා තියෙන්නේ for what? Screen sharing. Screen පෙවුන්නේ නැහැ කියන එකද? Jazzing multi listening, okay? Man, this is the problem. Next class, remember මං අහන්න ප්‍රශ්න වලට message දාලා උත්තර දෙන්න එපා. Unmute and talk to me because I'm only the person monitoring everything. Chat box, participants, messages from your university. So bit busy. So whatever, if I will ask any questions, if you will answer me by unmuting your mic, that will be very helpful. Now even I don't know for what you guys said. No. Okay. I hope that you all understood. Up to now we discussed. Don't think much. Next week also we are going to discuss certain things. At the time I will discuss some papers. They will be very helpful, and make sure to form a group. I can guide you much as possible because I know this is very hard subject. Make sure that you guys are enjoying studying. Make short notes. Okay. Do you guys have any other doubts?